Thank you, member. And recognizing the member for Oak Bay, Gordon Head.
Thank you, Honourable Speaker, and thank you to the member from Vancouver-Kensington for the eloquent words speaking in favour of this bill, a bill that obviously I'm rising to speak in support to, with recognition that perhaps there are some things that we might expand upon as we have this debate go forward. Some interesting ideas have been raised by members opposite, and I'm sure in the spirit of trying to develop the best possible legislature that, and with the new access that that members opposite have. Actually, Honourable Speaker, it's quite, government deserves a lot of credit for this. It's quite remarkable that they have given us access to legislative drafters to allow us to actually provide amendments to legislation, government legislation, on a trial basis this fall that could actually meet the issues that we raise, but at the same time do so in a manner that we know has spanned across the legislative framework. So when we put forward amendments, if there are any such amendments, we know that government could make a decision knowing that it has gone through legislative drafters, as opposed to, even if it's an amazing piece of amendment, having to say no because they're concerned that maybe legislative drafters haven't seen it. So I think the government deserves an awful lot of credit for providing access to both the BC Liberals and the BC NDP MLAs. I hope we collectively don't abuse that so that we get to have the access withdrawn, but I think it's a good step forward for our democracy, and perhaps members opposite will be standing forth with some legislative drafter approved or assisted upon amendments. Honourable Speaker, this bill that I'm standing to speak to Bill 8, Lobbyists Registration Amendment Act 2017, takes steps forwards in British Columbia for much needed lobbying reforms. But of course, it doesn't include all the reforms that everybody would want, perhaps. But it does make an important step forward. It's reforms because reforming lobbying is fundamental. It's essential to rebuilding public trust in our democracy, in government, and ensuring that special interests do not exercise undue influence on this or any other future governments. You know, Honourable Speaker, the Office of the Registrar of Lobbyists has issued a number of recommendations to reform lobbying in British Columbia, and our priorities for reform were drawn from and in line with these recommendations. Honourable Speaker, the BC Greens were the only party that formally campaigned on introducing lobbying reform legislation, and we're absolutely delighted that government has seen fit to bring forward a bill here to take steps towards improving the Lobbyists Registration Act by the amendments that are brought forward. In particular, the bill before us acts on one of the recommendations from the Office of the Registrar of Lobbyists, and that recommendation was instituting a prohibition on lobbying for former senior public office holders for a period of 2 years since leaving office. You know, Honourable Speaker, what does it mean now to say former senior and public officers? Well, Honourable Speaker, we're delighted with the definition here in Section 2 of the bill, where it says former public office holder means, and therein lies a definition, a former member of Executive Council and any individual formerly employed in the member's former office, other than administrative support staff. Honourable Speaker, why that's important is ministerial staff have access to information and ministers have access to information that most members here do not have access to. It's information on how this government is operating at a very fundamental level. So we support this inclusion of those within the minister's office. It also says a former parliamentary secretary, again, access to information that most members here will not have, as well as including members, Honourable Speaker, in government who are not in cabinet. Cabinet confidentiality is something that is respected not only with members opposition, but also members in government do not have access to the information unless they are in cabinet. And that's important that that be kept that way. So I fully support this ban, because going out into now lobbying a cabinet or a government where you have inside information potentially puts people into awkward situations, and I think we should try to avoid that. The definition further continues saying any individual who formally occupied, number one, a senior executive position in a ministry, whether by the title of deputy minister, chief executive officer, or another title, the position of associate deputy minister, assistant deputy minister, or a position of comparable rank in a ministry, or a prescribed position in a provincial entity, the famous prescribed position done through regulations. Now, Honourable Speaker, again, senior members of government have access to privileged information, information that in many cases is subject to cabinet confidentiality. It's information that is not available to the general public, and therein lies an important point. Sure, we want people with expertise to lobby in their area of expertise, but having inside information gives undue influence to various individuals. Kind of like insider trading, Honourable Speaker. If I know, for example, if I know that a company is about to go bankrupt, and I've been told by the chief financial officer of a company that the company is going bankrupt, and I act upon that by shorting that stock, that's illegal, Honourable Speaker. And the reason why is because the public does not tolerate the use of inside knowledge to undermine general public interest, which happens in that case. And that's the intent of this, and I applaud government for bringing forward legislation that's true to that intent. What's important, I've heard a number of members opposite speak about the fact that some staff may have moved off into positions now and they have to resign. I think that a case could be made based on Section 2.3 of this bill that's entitled Exemption from Prohibitions, that it says here, if the registrar is satisfied that it is in the public interest, the registrar may, on request, and on any terms or conditions the registrar considers advisable, exempt a person from prohibition set out in Section 2.1 and 2.2. And again, there's some more details the registrar has to do. So this doesn't mean, this is what I would like to see through further discussion, Honourable Speaker. The exemption is there. And if a compelling case can be made that somebody, well, honestly, I knew a couple of people who moved here from afar. They weren't political per se. They were very talented individuals who've since, because of the downsides with government, have lost their positions. One could make a case that they are impartial. They happen to work in the positions they work because of an opportunity for their career advancement, particularly young people. But we have the exemption here that the registrar could be approached with a compelling case. So I don't see this legislation, as some members have pointed out, as being particularly unfair to those who have worked in ministry's office. As I said, Honourable Speaker, the BC Greens, soon to be officially recognized in this House, I should say. So I should say right now, the three independent members who ran under the BC Green banner was the banner of a party, was the only party to actually campaign on lobbying reform. And frankly, it was one of our central pillars of our governance reform platform. And our confidence and supply agreement included a discussion of this. As in any agreement, it's not you bring your baseball bat and your ball to the game and then you stand up and walk and stomp out if you don't get your way. Clearly, if this is not 100% what we would have written, but on the other hand, we understand the importance of collaboration, the importance of listening to other views, the importance of actually reflecting upon your position and being willing to change or expand upon it based on new information as brought forward. And again, we commend the government on bringing this forward, recognizing that it is a first step. When we did our campaigning on reforming lobbying in BC, we wanted to see, first and foremost, an increase in the transparency of how lobbying takes place in British Columbia and an increase in the accountability of lobbyists and public office holders. So one of the things, again, to expand upon that, we wanted to see a requirement to disclose who one actually intends to lobby, removed from the Act, and replaced with a requirement to disclose who one actually lobbies within 10 days of lobbying. Let me tell you why we thought that was important. We recognize, of course, that lobbying is a natural part, an important part of political life. It's an important part for us to gather information as legislators on what the issues are facing various groups. It's critical, lobbying within the democratic system. But the public needs to know who is lobbying whom. And by making it more transparent then, decision makers, they're more accountable for their actions, but they're also, the public trusts them that when they make the actions, they've done so in an open and transparent manner. It's quite common, Honourable Speaker, for a lobbyist to say that they're going to lobby 87 members of the BC legislature. Well, 86, because one member has since stepped down. Well, that's not very helpful to anyone. So let me suppose I'm from the Deep Earth Coal Mining Company of Kansas. Well, let's say of, Prince, who was a member here, from Saanich South. The Deep Earth Coal Mining Company from Saanich South. It's very unlikely that that person would be lobbying the member from Caribou-Chilcotin or elsewhere. But if they list in the lobbyist registrar that they're lobbying all 87 members, nobody really knows who they're lobbying. But if they were to lobby the member from, or the Minister now of Agriculture from Saanich South, member from Saanich South, or the Ministry of Energy, we want to know that. The public would want to know that. They wouldn't want to know that they intended to lobby everyone, because they're not. They're obviously going to lobby whoever. And this is done with the greatest respect to the member from Saanich South. I just happened to look to see if there was someone in the audience here. So the purpose here is to register who you're lobbying to. And so we recognize that this is a first step, and we would hope at some point in the future, in this legislature, we'll be able to list who is lobbying who, as opposed to we're lobbying everybody. One of the second goals that we had in including lobbying reform on our platform was to reduce the undue influence of special interests on government decisions. I don't want to rehash all the last 4 years I've been here, or the last 16 years in total, or even the 1990s. We don't need to rehash all that. The reality is the public wants government to work in the interest of the people of British Columbia, not in the interest of vested interests. And one of the ways of getting that is reforming lobbying to get to transparency and to reduce undue influence. One of the things with doing the 2-year prohibition does, Honourable Speaker, is it does just that. It gives, in some sense, a cooling off period for those who've had that insider knowledge, so to speak, a cooling off period that allows them to, figure out what they want to do. Frankly, if it's an MLA, it's going to be tough when moving from an MLA. You're going from 24/7 a day to suddenly you have time on your hands. Going back to a university, Honourable Speaker, I tell you, as you would know from University of Fraser Valley, that's a cushy job compared to what we got here, having to work in BC Green, sitting on 5 committees. But they'll have time to reflect upon what they want to do, and maybe they won't become a lobbyist. And good on them, power to them, and build upon the expertise that got them here in the first place. Public office holders have, as I mentioned, special privileged relationships and access to privileged information that would give them, Honourable Speaker, outsized influence if they become lobbyists immediately upon leaving. And as I said, 2 years is sufficient time for these lobbyists to, in some sense, get a sense of what they want to do. We don't want government and senior civil service to be a revolving door, once government, then lobbyists. That's not good for a democracy. One of the third thing we wanted to do is we felt it was very important, and again, we're very grateful to government for moving down this path, was to bring BC's standards in line with other jurisdictions in Canada. As has been pointed out, we've been called the Wild West here in British Columbia, and I would argue in lobbying reform, we do lag behind other jurisdictions across other provinces and at the federal level. In 2008, the federal government imposed a multi-year prohibition on lobbying. Now, where kudos go to the Harper government at the time for doing just that. A multi-year prohibition on lobbying was in recognition of the undue influences that could have the special interests of somebody with inside knowledge lobbying as soon as they left. We know that Alberta, Saskatchewan, Ontario, Quebec, Prince Edward Island, Newfoundland, and Nova Scotia all have so-called, quote, cooling off periods as well for former public office holders, and the variety of lengths. Here we've got 2 years proposed, and they also have more stringent requirements for reporting, codes of conducts, and so on and so forth. Honourable Speaker, this bill goes a long way towards reducing some of the problems that we face here with lobbying in British Columbia. Coming back to what this bill does. This bill, as I've said, takes steps forward for much-needed lobbying reform. But it does not include all of the things that we felt were necessary, but it does make a good step forward. The 2-year prohibition, wonderful. What's also really important is, and frankly give government credit for this, is that they've committed to undertaking a review of lobbying. Government has said that they are committed to undertake a review of lobbying. I think that's a good step forward, and I hope we get a multi-party agreement that this is something that we could do. This is not a partisan issue, Honourable Speaker. I recognize that there are a few individuals who this legislation might actually cause some difficulty for right now, but we do have that exemption in Section 2.3 that they could seek to apply for and make the compelling case why it's important that they continue as lobbyists. You know, by committing to undertaking lobbying, I think we all will have collectively a chance and an opportunity to actually bring our views to this. You know, Honourable Speaker, I do note that Chair of Committee has entered. I do note the hour, and I reserve my right to speak on this matter further on Monday, and do so move adjourned debate just now.